I'm here to talk about 3 ridiculously huge mistakes parents make when loaning children money. I'm Claire Langton Yanowitz, an attorney at the Yanowitz Law Firm, where we help clients in Minnesota with wills, trusts, and probate. Okay, first big mistake that people make is they don't know whether they're loaning their children money or they're gifting their children money. I talk to parents a lot where people, parents will give children money and then they'll say, well, I lent them money. And I say, well, are they going to pay you back? And they say, well, they don't think that they're going to ever pay me back. And so if you give someone money and you don't expect them to pay you back, that would be considered a gift. Second big mistake that people make, if it is a loan, that you do expect to be repaid, then you need to put it in writing. And that's really important because when parents are gone, children can fight about these things. How much did you owe mom and dad? How many payments did you make to them? What's the outstanding balance on the loan? So it's good to put it in writing. It's important that you charge an interest on the loan. It's required that if it is a loan, not a gift, that you charge interest. And there are minimum interest rates you must charge on a loan, and those are called AFR rates. It's something that you can Google online and you can find it. They're listed monthly. It changes monthly on what are the minimum required interest rates you must have on a loan. So must have an interest rate, should be in writing. And then once that loan is in place, it's important that you document when your child pays you, so that if you were to die, the outstanding family members would know how to calculate what is left for payment on that loan. The third mistake that I see people make is that they don't address these loans in their estate plan. What do I mean by that? So if you die and your kid still owes you money, do you expect them to still pay you back, or are you going to forgive the loan? So if you expect them to pay you back, oftentimes, so let's say they owe you $50,000 and their share is $200,000. That's their share of money. So if you expect them to pay you back, generally their share will just be reduced to $150,000 because they'll just get left less in payment of their loan. Okay. Now what happens if the value of the loan is greater than their share of the estate? Okay. So let's say they owe you $50,000, but they're only entitled to receive $30,000 of your assets at death. Do they need to come up with that extra $20,000 to pay off the estate, or are you just going to forgive the difference? So that's something that should be addressed. Another thing that should be addressed is if your child dies before you do, hopefully that never happens. That's a scenario that we never want to walk down. But if that does happen, do you want, if the grandchildren of that child were to inherit, let's say they have 2 kids, do the grandchildren's share get reduced? Some people would say yes, some people would say no. It's important that your estate plan clearly defines that. And then another thing that should be addressed is whether you want to charge interest on the amount that they owe you. So let's say sometimes people will say, I made a gift. Right? They don't make a loan. They make a gift. They gifted Sally $100,000 when she was getting a divorce. She needed the money, and so they want to reduce her share at death. Okay, so she gets $100,000 less at death because we made her this gift during our lifetime. That concept in the legal world is called an advancement clause. We advanced some of her inheritance while we are alive, so she gets less at death. So if you are in that situation where you've made a gift and you want to reduce the share at death, then a question I would ask is, well, do we need to charge interest? You gave her money in 2022, but then you died 30 years later. Do we just reduce her share by $100,000? Or does that amount increase because, the time value of money 100,000 today will not be worth the same amount 30 years from now. That would not be accurate. I would say that the majority of my clients would say, no, just reduce it 100,000 at my death. Keep it simple. But that's something to consider because, that kind of strikes at the heart of, what's fair, how do you want to handle things? So that's something to consider. Thanks for listening. If you have any questions, feel free to send us a message or check out our website at www.yanowitzlaw.com. Thank you.